The court agreed, maintaining Beyond had no contractual right to sterilise Curro's talents and keep her away from the viewing public for up to 3 years. This principle of giving work to certain types of entertainment-related employment contracts has been extended to professional sportspeople. It's possible, of course, for an employer to opt out of the obligation to provide work, that is, specify in the employment agreement that there is no guarantee that opportunities must be found for the employee to perform. It may well be that BT, a former lawyer, succeeds in ultimately doing so with the NRL player contract. Above and beyond, Tracy Curro, second, from right, during her 60 Minutes days, after leaving Beyond 2000, however, the principle remains. The law recognizes the importance of giving a footballer the chance to display his wares in public and improve. In the case of de Belin, 28 next month, it means the Dragons must offer him the opportunity of playing for the club and being available for selection for New South Wales and Australia. Furthermore, his club has an obligation to allow him to showcase his talents before future employers, that is, the other 15 NRL clubs in England's Super League. Read the extract from the New South Wales Court of Appeal 1993 decision and substitute de Belin for Curro and St George Illawarra for Beyond. She was entitled to be given work of appropriate quality to keep her name and talent before the public with reasonable frequency. In our opinion, Beyond had no contractual right to sterilise Miss Curro's services and keep her away from the viewing public. On the contrary, any attempt by Beyond to act in that way would be a repudiatory breach entitling Miss Curro to rescind and sue for damages. Should BT, therefore, order the Dragons to stand de Belin down, or convince the ARLC board to instruct NRL Chief Executive Todd Greenberg to do so, de Belin's lawyers can injunct the club code. Not only is the Curro case inconsistent with the idea that it is appropriate to sterilise the player's career, simply because he's facing criminal charges. The 2 years Curro would have been without real work also dovetails with the same period of de Belin's career that would be lost. It's not only the courts which have established the link between sportspeople and entertainers. Over 30 years ago, the late American social critic Christopher Lasch described the full-time athlete as a new class of worker produced by the information age, an entertainer who sells his or her skills for money in the same way songwriters and sound technicians do. ARLC chief executive Ian Prendergast, like BT, is a lawyer. He may remember an expression made famous in a 60 Minutes episode hosted by Curro. It was the occasion Curro interviewed Pauline Hanson and asked the One Nation leader whether she was xenophobic. Should BT demand de Belin be stood down, Prendergast and St George Illawarra's legal team could point to the judgment in the Curro case and answer in the same way Hanson did, "Please explain."